Check, check. Okay, peace, peace, peace. Sorry about that. I didn't have the audio on. So I'm going to have to go back and edit that. All right, peace, everyone. Today we are going to do part 2 of the video that we were watching yesterday. As I was saying, the words that you see on the video, they come from, I took it from somebody's channel who's actually, they do reviews on sovereign citizens and they do everything they can to make them look bad. So like I said, I'm counterbalancing all of this with my own review. I haven't watched these videos, so it's my first time watching them with you. I haven't watched this, so I don't really know what's going to be said. It's about 30 minutes long. So let's get into it. Let's see what they're talking about, all right?
And on the Zoom call there, it says, it's going to read the trustee of the person, Mohammed Idris. Could you come on the Zoom call?
Can you hear me?
I can. Can you activate your camera?
Yes, just give me a second.
Hi there. So are you, is it Mohammed Idris?
The trustee. I'm the trustee. The trustee of the person is here, and all the beneficiaries have been already named.
Okay, so I'm looking for Mohammed Idris. If you're not him, you're free to go. We'll issue a warrant for him.
Once again, I'm going to caution everybody, don't get caught up in this name shit. That shit, they have gone into meetings. That used to work a long time ago. You need to be a little bit more creative. What you're trying to do is you're trying to let him know, for all of you watching, you're trying to let them know the all caps name. This is for the people who don't seem to understand. When you look at a caption of a pleading, because there's a lot of people that's new and they don't know, why is he saying he's the trustee? He's a damn fool. He's a fucking fool. Let's look at this real quick. So I'm going to ask all the people a question who, you know, you've probably been in a court case before. All right. So this is a pleading. This is a courtroom pleading. Now you're going to notice that on all of these pleadings, the name is always in capital letters. Now, to the layman or you idiots out there who don't know anything that's going on in the world, you just think it's just, you don't think there's nothing to it, that your name is all capitalized on your driver's license, that your name always appears capitalized on all of your utility bills, that your name is capitalized on your birth certificate, on your social security cards, on just about anything that's coming from the government. Your name is always styled in all capital letters. This is because there's a public and a private, and government only interacts with other artificial entities. This also gets into the fact of what jurisdiction has been assigned to the government on the state and federal levels. Jurisdiction is given to the government by the Constitution for the United States of America. Okay, in that Constitution, government only interacts with other artificial persons. Now, you may not understand that. All right, so to you, it sounds weird when he comes on and he doesn't want to answer to the name. Answering to the name gives them in personam subject matter jurisdiction over you, as well as the fact you have just admitted on the record that you are that person. All right. What he's letting them know is, look, that name on this is a legal fiction entity. Let's look at this real quick. What is a legal fiction? Everything in their system operates off of legal fictions. So let's look and see what a legal fiction is. Because, you got a lot of people out there, they say the man is crazy. It's crazy because he's just sitting there, he's talking about he's a trustee. Well, why is he saying all of that? Well, the reason he's saying that is because everything in the court system operates off of legal fiction. You can get Lon Fuller's book, Legal Fictions, which is basically, it's kind of like the Bible of legal fictions in the legal community. But a legal fiction is an assumption that something is true, even though it may be untrue, made especially in judicial reasoning to alter how a legal rule operates. Specifically, a device by which a legal rule or institution is diverted from its original purpose to accomplish indirectly some other object. The constructive trust is an example of a legal fiction. So right here, this constructive trust and equity is what he is addressing. He's looked at as a trustee ex maleficio. Okay, what is a trustee ex maleficio? Well, let's look at that. What is a trustee ex maleficio? And here it is right here. See this trustee ex maleficio? What is that? A person who is guilty or wrongful of fraudulent conduct and is held by equity to the duty of trustee in relation to the subject matter to prevent him or her from profiting from wrongdoing. Okay, so we're talking about a constructive trust. Okay, and then a trustee ex maleficio. This is where they're getting this trustee from. Okay, in case you're wondering why, it's a constructive trust. And there's a basic principle of trust law that the trustee has all the liability. So they're assigning, or under a presumption, that that when you come in, that you're going to represent the defendant and you're going to take on this liability of trustee. So you countering that by stating, no, I'm not the trustee. This is what people talking about. They're expressing the trust in court. I'm not the trustee. You're the trustee. I'm appointing you the trustee. I'm the beneficiary. Okay, this is now, where they get this thing about the corporation, the corporate entity, they found it in Louisiana. Let's see if I can find it to you. It's called an affidavit of denial of corporate existence. Now, this comes out of Louisiana. Somebody was doing some research in Louisiana. And this is what they find right here. This is under criminal procedure. See, corporate existence is presumed unless affidavit of denial filed before trial. On trial of any criminal case. Notice the word, any criminal case. Now, this is in Louisiana. This is why you have to look at other state statutes, because this basic principle is applicable in all 50 states. Some states are more transparent than other states with their statutes. Georgia is very transparent on some things, like silence is acquiescence and things of that nature. So the states, all the states, they have the same legal principles that they have, but some of them are just more transparent than others. Here in Louisiana, you can see under y'all criminal statute, if you're in Louisiana watching, this right here is criminal procedure, okay? In any criminal case, it shall not be necessary to prove the incorporation of any corporation mentioned in the indictment unless the defendant, before entering upon such trial, shall have filed his affidavit specifically denying the existence of such corporation. All right, so this is where this affidavit of denial of corporate existence came from. So when you are looking, okay, so what are these, Yusef, how does this apply to us, Yusef? Well, when you look and you're looking at what these guys are coming into court and they don't want to answer to the name, okay, what they understand is that all caps name is a corporate entity, because that's all the statutes and everything only deal with corporate matters. It's corporate matters. Now, they don't want to say this. This is the big secret, and this is what we're trying to expose. So if you're new to this and you're just watching and this sounds like a whole bunch of hogwash to you, I would reserve your comment, because you're going to end up looking like a damn fool. Trust me, you are. Okay? So, this is where that came from. So you have an affidavit of denial of corporate existence, which you can find one in Abatement at Common Law by Don Quixote. There's no such thing as a get out of jail free card. That type of thinking right there is going to get you fucked up. I'm not here to make you think you're going to get out of jail free. If you kill somebody, your ass deserves to go to prison. If you are drunk driving, you deserve to go to prison. If you are molesting children, you deserve to go motherfucking prison. All right? There are things that you do, you deserve to go to fucking prison. Fuck you. Lock your bitch ass up. I'm not in any way here trying. One of the rules is being honorable. If you are not an honorable individual, fuck you, take your ass to prison. Now this shit is going to work for you anyway, because you're not going against the system. You're going against the creator of the balanced universe. And you have incurred karma, and you got a price to pay. All right, so let's get back into this. I think that's enough backstory for right now. I'll add some more of it a little bit later to add some more context. So just so you understand, this is why he doesn't want to answer to the name, because that all caps name is an individual. Let's look at this real quick, because we got to be thorough. I got to be thorough. Okay, and in tax law, there's only 7 entities that are recognized. All right, only 7. Let me give you. Let me put them up here on the chart for you. Now, right here, you can see that the IRS recognizes all these different individual entities. So you have an individual, an association, a partnership, a company, a corporation, an estate, a trust, and private trust. It's just 7, a trust. So we got trust, all right, all 7 of those entities. You need an artificial person to operate in commerce. They had to give you one. So they give you one by default, and they call it an individual. That's why you have to file your individual tax return. But you're under some sort of presumption that an individual is a person, I guess. But let's take a look at this real quick. Let's look at the word individual in the Black's Law Dictionary. Let's look up what an individual is. We gotta know what we're dealing with, so we don't, because there are people watching, so we don't want to look crazy. Because you know they're gonna come over here, because I'm using the same keywords that all these other guys are using over there. So we're gonna get a lot of traffic from the people who are over there laughing at the Sovereign Citizen fail videos. And we want to welcome them with open arms. If you're one of those individuals, we welcome you with open arms. All right, so individual. What is an individual in law? Because I know y'all ain't, all you people looking, y'all ain't never looked up those words. You think the words in law have the same meaning that they do in everyday parlance. They don't. They don't. So look at this word individual. Individual. Let's read this. What does it say? Individual, existing as an indivisible entity, sense two, of or relating to a single person or thing as opposed to a group. So here we got a word person, and we're going to get into a discussion of what a person is in law. That is a corporate entity. That is a legal fiction as well. And it's an entity. All right? It's an indivisible entity. Well, what is an entity? Let's look and see what an entity is. What is an entity? It's an entity. An individual is an entity. Once again, we got to start thinking and we know the meaning of these words. Stop. That's where you're going to mess up. That's why they can pull you in the court, make you look like a damn fool because you don't know the definition of these words. What is an entity? An organization, such as a business or governmental unit that has a legal identity apart from its members. So right here, you can see quite clearly that my man is trying to separate itself from any sort of nexus to this corporate created entity, this ens legis, this nom de gore, this legal fiction, this trade name, this transmitting utility, a plethora of other names, a straw man, whatever name, a franchise. It's a lot of different names that have been applied to it. I think franchise is one of the best descriptions of it, and transmitting utility. All right. But whatever it is, it's a legal fiction entity. That's why they stylize it in all cap names. Everything in law is a science. So if you're new to this and you don't understand that, they don't just we're just going to put it in all capital letters. No, they don't do anything, just do anything. There's a reason for everything. There's a reason why your name appears in all caps. There's a reason why when you watch your senators on television debating in Congress, all their nameplates are in all capital letters. And the judge's name is in all capital letters. That's why he's on here doing this. He's trying to let the court know that I understand that that's a legal fiction entity and I'm being deemed as some sort of surety for that particular entity. That liability for that is on me. That this is civil in nature. You're hiding the fact that it's a corporate entity and you're hiding the nature of it that it's civil. I'm broadcasting right now. All right, civil. So I had to give you some backstories to this now. All right, so now, if you're new to this, and your dumb ass is sitting over there watching one of those sovereign citizen veil videos, having you a good laugh with all the rest of the liberals and the Zionists and the traitors to the Republic of the United States of America who don't understand that this is a free country and your government, the judge sitting on the bench, the attorneys, they all public servants with an emphasis on servant. You probably think the judge is a god. Probably one of those type of individuals. Anyway, let's get back to it. I think I got the crowd fired up good enough now. Y'all rolling with me? Check, check, check. Okay, check, check. Check, check. What the hell happened? All right, check, check, check. Okay. All right, let's get back.
I am the trustee of the person.
So, okay, I'm not sure what that means. You're going to have to explain that to me. I mean, I know what a trustee is. When they have a trustee over as a person, that's someone who governs their affairs if they're not able to manage their own. Generally, people aren't trustees for themselves. And so that's why, and if you're I'm not sure exactly what that means, and you're gonna have to explain that to me.
What I mean
Like I
by
say,
the
if you're, I mean, I'm sorry.
what I'm saying is the trustee of the person is here, and all the beneficiaries are already been named.
Okay. It's not your job to explain anything to the judge. If judge needs to be explained something, you suggest that he go get himself legal counsel. Okay, if he don't understand things, it's not your job to be explaining your process or anything. Matter of fact, that is a dishonor, and that is getting you deeper into their jurisdiction. Every time you answer a question, you're going deeper into jurisdiction. Every time you answer a question. That's why you got to style questions to answer with a question. You know, instead of say, you're going to have to explain this to me. Well, you said, well, Your Honor, you got to ask a question. I always go right back into that. Anytime they don't understand something, I say, okay, well, Your Honor, let me ask you a question. It is my understanding that I have a constitutionally protected right to know the nature and cause of any action. And it seems like there may be some confusion. So for clarity on the record, I have a question for you. Is this a civil or criminal action? Well, this is a criminal action. Thank you. Let the record reflect that the action being brought against the defendant is a criminal action. Now, sir, I have another question for you. The Constitution for the United States of America only grants this court two criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Now, sir, would you please tell this court and myself under which two of these jurisdictions that you're trying this criminal action? Because in order for me to mount a fair defense, I need to know, because the rules of criminal procedure are different for a common law action as opposed to an admiralty action. So please, sir, do your job and inform me of which jurisdiction you are operating under. You got to ask questions because they're operating under a presumption. They're presuming everything. They're operating under presumptions, assumptions, and color of law. They're presuming you're a U.S. citizen. They're presuming that you don't want to know that it is a civil action. They're presuming that they have a right to that you already know all of this. Because what is one of the principles of law? Ignorance of law is no excuse. So they have a right to presume that you already know all of this that we're talking about. Because we publish everything in the law book. We operate under plausible deniability. What you talking about? Everything is published. That's why we got to come on here and talk about the law. Because in 1 minute, they'll be telling you, oh, you over there listening to that crazy sovereign citizen stuff. And then the next breath, they'll tell you ignorance of the law is no excuse. Which one is it going to be? So he don't need to be trying to get into too much explanation. Let's keep going.
And it's on a trust, and that trust is private.
Okay, do you have a name?
Because you are claiming that you are the trustee, or the prosecutor is claiming to be the trustee, and the investors
No,
are
I'm
claiming
not.
to be the beneficiaries.
So, okay, I'm going to stop you there for a second because I'm not claiming that. No, you can't finish. When you say you are claiming to be something that I'm not doing, no, I'm not going to say that because that's not true.
And the judge is absolutely right. Don't be putting words in the judge's mouth, man. He didn't claim to be nothing. Everything is on the record, man. You're making a record. There's a transcript. The appellate court judges are going to look at the transcript and say, where did the court say that they were the trustee or claim to do anything? You're making it a presumption right now. You operating in presumptions. You ask questions because there's a principle. Anything you say can and will be used against you. That don't just go for you, it go for them too. Equality under the law is mandatory. Another principle. Equality under the law is mandatory. No one is above the law. Appreciate that. I'm just a messenger. I've been waiting for you to do this. No other so-called guru is doing this. Well, I mean, I just kind of stumbled up on it. It's like, I said, I ought to do some reviews. Because I used to hate to look at these sovereign citizen fail videos. But you know what? There's plenty of material out there. There's enough material on the internet for me to do this every day for the next 5 years, probably. That's how many of these videos are on the internet now. It's like, there's so many sovereign citizen videos. I'll say, you know what? Let me start doing some reviews, because reviews are very popular. We need somebody in our space to do reviews. You know, people in other spaces are doing reviews. Hell, why not we do some reviews of some stuff? I think it's a good teaching material, and, you know, we can kind of see some things too. Like yesterday when he asked for that bid bond, you see the silence? That was significant. I want all y'all, that is the response you have got. I've seen every single time that somebody asks for the bid bond. That's what I get here is silence. I don't even care if it ain't even in court. I could be speaking to an attorney and hit him with the bid bond. He gets silent. That bond is what Gene Keating was talking about. It's a bid bond. They form a bond. See, the reason, why is there a bond? Okay, this is for everybody listening. There's a bond because the statutes represent a charge. A charge is a lien. A charge is a lien. Let's look at that real quick. What is a charge? What are charges? When somebody puts some charges on you, you ever stop and think about what that word means? What a charge is? Let's look at it real quick and see if we can get some insight into this word charge. All right, so back to our trusty Black's Law Dictionary, 8th edition. Let's go to the C's. Let's look up this word charge. Here we go, charge. Okay, charge. A formal accusation of an offense as a preliminary step to a prosecution, a murder charge. Okay, we all familiar with that, the general term, but look how many senses of the word, look how many different definitions of the word charge we have. How do we know what meaning they are using when they call we're getting a charge? It says an instruction or command, all right, jury charge. Okay, review the charge for appealable error. For an assigned duty or task or responsibility. But here's the one, an encumbrance or lien or claim. So if somebody's putting a charge on you, could they be having a claim against you? And if they have a claim against you, so if, let's say that possession with the intent to distribute, that's a charge. Well, there is an amount associated with that because it's dealing in commerce. This is where the debtors' prisons came from. Under Edward I, with the statute merchant, in case you're wondering, well, where did this come from? It's not nothing new. They've been doing this for the last 1,000 years. So a charge, possession with the intent to distribute, okay, that's $1 million charge. They don't tell you that, but it's $1 million on the books. It's showing in accounts receivable. So when you come in and you start arguing, they say, okay, well, you don't want to pay the debt. You are an absconding debtor. So we're going to hold your body, and then we're going to take this debt, convert it into a bond, and sell it. Now you get an indication of how the government is funding themselves, all right? Because they'd already told you that all your taxes, the 100% of the Reagan, he did the investigation, and 100% of y'all taxes get just paid on the interest. So how's government funding themselves? They having to make money through charges. That's why you see this mania for writing you traffic tickets, and you're getting a charge for every little thing. Because money is created off of debt. So one of the rules is there is no money. The reason that's the number one rule, because everything in our system today revolves around that fact. That since there isn't any money, debt is being used as money, so everybody is looking for an opportunity to create money by creating debt. Debtors' prisons. So that's why you're getting the backstory. So we need to know when they say I'm getting the charge, well, what are you talking about, Judge? Now, in case you're out there wondering, because you may be saying, well, you know, you may be an attorney looking and you need a little bit more proof. All right, let me see if I can get you some more. Let me see if I can get you some more. Then we're going to get back to this. I'm going to see if I can get you some more because I know you ain't convinced yet. You ain't convinced yet. You ain't convinced. Some of you attorneys already know. You already know. But I know some of you ain't convinced yet. You ain't convinced. Let me see if I got it on here. Oh, shoot. Oh, man, don't tell me I had to do this. Man, I'm going to have to show y'all another day because I don't have my, hold on, let me see if I got it in here. That my other phone in the truck. So I'm going to have to come back, y'all, on that. But I'm going to show you in Georgia. I'm going to show you this. I wanted to show you the actual law book. So, but in lieu of that, I'm just going to show you the code in Georgia. And I'll show you the law book later because you really need to see this. So you got OCGA 17-11-1. This in Georgia. All right, so right here, you see right here, they got this in your code. Imposition of cost of prosecution upon the defendant generally. The cost of a prosecution, except the fees of his own witness, should not be demanded of a defendant until after trial and conviction. If convicted, judgment may, this word may means must. Do not believe that, look this word up. It means you have to do something. It does not have the same meaning that you use every day. Judgment must be entered against the defendant for all costs accruing in the committing and trial courts and by any officer pending the prosecution. The judgment shall be a lien from the date of his arrest on all the property of the defendant. The clerk shall issue an execution on the judgment against the property. So right here in Georgia, when I show you how transparent they are, they're showing you that when you get convicted of a crime, they put a lien against you. Well, the only thing they can put a lien against you is your social security number, because that's the only attachment to your property the government has. So now a lien is evidence of a debt. And if you got evidence of a debt, that can be discounted and sold on the markets. This is not too hard to see. This is why we asked them, Your Honor, I request that the Honorable Judge provide the demand that the prosecutor provide the assessment for the charges along with a certified audit trail of all transactions, including all disbursement documents and receipts. I'm asking for an accounting of this whole case because you operating under some sort of presumption that money, that this is a criminal case and it don't have nothing to do with no goddamn money. We all know that that's a damn lie. Everything's about money with these people. You go on and keep believing this about truth and justice in the American way if you want to, and you know deep down in your heart you sound like a damn fool if you believe any of that. Truth and justice in the American way. Hell out of here. All right? So the next one is not just this. Well, let's look at another one. OCGA 70. This is why they bound over all cases. They bound over all cases. Right here. 70, imposition of costs and payment of costs on the prosecutor or complainant imposition of costs and jail fees upon the prosecutor or complainant. The prosecutor's name shall be endorsed on every indictment and should be compelled, and he shall be compelled to pay all the cost and jail fees upon the acquittal or discharge of the person accused when, number one, the grand jury by its foreman on returning a no bill expresses as its opinion that the prosecution was unfounded or malicious. Number two, a jury on the trial of the prosecution finds that it to be malicious. Or number three, the prosecution is abandoned before trial. When it is thus abandoned, the officer who issued the warrant shall enter a judgment against the prosecutor for all costs and enforce it by execution in the name of the state or by an attachment for contempt. What is an attachment for contempt? If you look that up, that's a warrant for an arrest. So they bound over everything. I could go deeper with this, all right? I could go deeper with this. But I have to give you this context because now when you're watching this guy, he got a little bit of knowledge. All right, this is the knowledge that he's operating from. When you put it, because see, a lot of people watching this, you think the man look crazy. Now, when I tell you all this, does he still look crazy? Or is it that you just an ignorant ass individual watching what's going on in these courts and you don't know what the fuck is going on because you don't take the time to read your own goddamn statutory codes or to check your public servants or doing oversight on their ass, and you sitting there looking and seeing that the country is $31 trillion in debt and you don't think that it is affecting everything in our society? You can't be that stupid. This is what it's about right here. Your country's $32 trillion in debt. All right, right here. You see that right there? The clock's never moving. Everything is a deadbait. You'll never pay that off. You are a slave to these people. As it says in Leviticus 25:45, you're a bond servant. This is a fictitious debt. They need any money to pay it back. All right, that's what we got to do. We got to reduce the national debt by giving these people negotiable instruments. Look at that. Who can in a right mind cannot look at that and can't see what kind of trouble the United States of America is in? You think that shit don't mean anything? Is that what it is? You think that don't have no application to you whatsoever? This is the reason for everything. All right, let's continue. That's enough context. Let's see what my man is talking about.
I'm not claiming to be anything other than the judge in Thurston County District Court who's on this calendar. So I'm not the trustee of anybody.
Well, you're here to come after my personal trust, correct?
No. Why would you think that?
I object being a trustor.
Okay, well, you're not one. I'm just trying to find out who you are.
I can't get any clearer when I said the trustee of the person is here.
Okay, is the person here? Well, you're not going to answer that.
The trustee of the person is here.
I'm not claiming to be anything other than.
Okay, if he wants to ask is the person here, well, I will conditionally accept the fact that the person here is upon proof of claim. You can provide me a definition of the word person, because my understanding person comes from the word persona, okay, which a corporation is a person. Legal fictions are person, trust are persons, corporations are persons. So when I ask is the person here, all right, that's what you got. We have to find out. What do you mean when you say person? That is a word that everybody in here needs to study. That's a study in itself. What does the word person mean? Thank you for the bones. Thank you for the $9.99. I'm just a messenger. Appreciate that. All right. So we need some clarification. Okay, what do you mean by person? Is the person here? You got to look at the he asked the question.
The judge in Thurston County District Court who's on this calendar. So I'm not the trustee of anybody.
Well, you're here to come after my personal trust, correct?
No, no. Why would you think that?
I object being a trustor.
Okay. Well, you're not one. I'm just trying to find out who you are.
Okay, at this point, the judge is getting very comfortable because he's obviously tail spinning. He don't know what he's talking about. He jumping all around. He don't want to be the trustor or the person who creates the trust. He just throwing out words right now he don't know the meaning of. A trustor is a person that creates a trust. You have a trustor, settlor, grantor, creator. Those are 4 words that mean. When he say coming after the trust, he's talking about the all caps name, which is a legal fiction entity. A trust is a person. They're just showing you that they're trying to put an attachment against his social security number because that person is only thing that represents in their records is the social security number. So all they have to do is put a lien against that number, and that it has value, and that it can collateralize it by holding you in jail. Now, if you want to study this, I'm going to put under this video the Gene Keating prison treaties and the Gene Keating transcript that goes into detail about what I'm talking about right now. He conducted probably the most ever research on the prison industrial complex. I had the B424 for Correction Corporations of America, which is their trust indenture agreement. They have an agreement with the government to keep the prisons 100% occupied, and they get a per diem for every day a prison bed is filled. That's right there in the B424 prospectus. I don't have to guess that shit. So right now, he's tail spinning. All right. The judge don't want to be the trustee. He's making that clear. Because what I tell you, the trustee has all the liability. So he's taking a little time out there. And look, I'm not the trustee. I'm just trying to find out who you are. Don't keep going back and forth. You say, hey, look, for the record, Your Honor, my name is so-and-so and so-and-so, John Henry Doe, and I like to spell it for you. Capital J, lowercase o, lowercase h, lowercase n, capital D, lowercase o, lowercase e, all right? And for the record, and I'm the holder in due course. Here is a third-party intervener making a special appearance as an authorized representative for the defendant. All right? Just like that. Because, see, that name thing is important, but it's not so much the name, it is the office that the name is occupying. Are you a beneficiary or are you a trustee? Do you have the liability or not? This is about shifting liability. And they teach you this in creditors and their bonds. It's called the hot potato game. Matter of fact, let's take a little time to read the hot potato game so you can understand what's going on right here. Let's read this real quick. So on SPC University, and all right, so let's read this real quick. It all has to do with trust. Who's the beneficiary? What is the trust corpus? Who is the trustee? Where is it at? Public defender. Hot potato game. Okay. Let's read. This is why you always use a public defender. If there is a court involved, the judge may appoint a public defender for the defendant. You are not the defendant. The straw man named on the presentment was chosen to be the defendant. The presentment is an indictment because that indictment is a negotiable instrument. You need the original matrix. Matrix means original. You ask them for the matrix. Remember rule number 1, the public and the private can never be mixed. They can't do it and you can't do it either. That's why you got to remember public and private don't mix. If you're a private citizen, how can you be listed on their documents? Public and private don't mix. That's why they only interact with other artificial entities. All right? They don't ever mix them. Be careful you don't either. If the defendant has a public defender, this is good. When the prosecutor signs the complaint, verifying it, and his signature is notarized, he's taking on the liability that may follow in the event it is discovered the complaint is not valid. Remember, I just read you that in OCGA 1711-4, liability of the prosecutor. He has taken a chance because at that point, he is the only attorney of record. He has filed a form of notice of appearance by filing the complaint or filing the grand jury indictment. He technically represents the defendant until someone else takes his place. He's counting on someone appearing in the case to defend against the complaint. If that doesn't happen, he is the responsible party and liable for all the cost. Notice that we keep seeing this word cost come up, prayed for. I just showed you that in OCGA 1711-4 in the complaint or associated with the statute violations. If that does not happen, he is off the hook. Almost 100% of the time, that is what happens. He is pretty safe taking that chance. Usually, the straw man named in the complaint gets a good attorney to defend him. That means the defense attorney is taking on the liability, right? Not so fast. He does not take on the liability until he signs a notice of appearance and files it in the clerk's file for that case. Once he is the attorney of record for the defense, he is on the hook. Now he has to get someone to take his place. The likely taker of that position is the straw man named in the complaint, indictment, or traffic ticket. The straw man can't talk, so someone has to represent it. Usually, that is you, because you have a point to make, or a lesson to teach, or testimony that will prove your case. Wrong choice. This is almost always the losing proposition. Really good all-point paperwork has been put in court for decades with a very low success rate. The only way to win is to let the state win. I love win-win situations. How can you win and the state win at the same time? If you accept and return the presentment and exchange it for exemption for the discharge of the charges, the state gets the credits from your exemption and you get the discharge when you bond the case. Well, that sounds easy, right? Okay, let me stop right there. Okay, what he's saying. What he's talking about is the liability, the shift of the liability. This is why you see people don't want to take on this name, or they doing everything they can to avoid saying that's me. All right? Because the all caps name can be represented. The attorney represents it. That's why you can't talk, because the attorney is representing the defendant. But what they do is they get off the hook when they get you to plead guilty or not guilty. That's when you have the liability. That's why arraignment is the most important point in a criminal case. That's why also an attorney will come and say, I'm going to waive your arraignment. He makes it seem like it's not a big deal because he put in a not guilty plea for you. But if you go and check the discovery, every time he makes a notice of entry of appearance, immediately after that, he's going to put in a plea for you because he's taking off that liability off himself and he's putting it on you. And you can find this in the court, in the statutory codes. I didn't just read these documents. I went looking for evidence of this. I hope y'all are getting it. Let's continue.
I can't get any clearer when I said the trustee of the person is here.
Okay. Is the person here? You're not going to answer that.
The trustee of the person is here.
Okay.
And the beneficiaries have already been named. Is on a trust, and it's private, and my trust is private.
Okay. What's the state's position on where this case?
Okay. Now y'all can see his execution is terrible. He just sound crazy. It's how he's saying it. What he understands what's going on, but he do sound crazy. He look, and for the untrained eye or the person that don't know none of the stuff that I just told you, he sound fucking crazy. What it is though is this. He's nervous and he don't want to make any mistakes. So he's being very careful of his words. See, the judge is testing him with these questions. Is the person here? Anything a judge says out of his mouth is something to it. They're well trained in psychology and their approach. They don't say anything for no reason. Yeah, let's get these likes up. Y'all like me doing this, right? If y'all like me doing this, it's 329 people in there. It should be 329 likes. And throw some money in the pot. Y'all see them buttons down there with them dollar signs on it? Where we at with the likes? Where these likes? I'm talking about. Likes up. Okay. All right. All right, that's better. All right, let's continue. But he sound crazy. Okay, he's sounding crazy right now. Let's keep watching. Let's see how it turns out.
Is headed, and then I can come back and speak with
Your Honor, if
who I assume the trustee of the person is the person named as Muhammad Idris. And so, but let me hear from you what the state's position, these cases look like there's a fraction of failure to control a traffic device. There's a special fuel trip permit. And then there's a failure to comply charge.
Yes.
So what's the state's position on where we're going from here?
If Muhammad Idris is not present, the state would ask for a warrant.
Muhammad Idris
If we're
I'm going to
going to
consider him present based on his verbiage. I know he's operating under a lot of false premises, but that's kind of on him. So,
Right.
but I mean, what is the state where we're at here? If the state wants to go to trial on this case, we'll set it for trial, and then
The state would ask the court to set dates.
Okay.
In speedy trial, the state also would like to clarify whether Muhammad Idris is intending to go pro se or if he will have counsel.
Okay, this is one of their favorite moves is I try to send you to trial. So, because you can argue. Okay, the thing about it is none of what we're doing is made to go to trial. This is why you say what you say. You say, I'm the holder in due course. Here's the third party intervener making a special appearance as an authorized representative for the defendant. I accept for value and return for value all the charging instruments in this matter and make my exemption as principal available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts contained in the charging instrument. Please use my exemption for offset and adjustment of the public charges against the defendant and release the order to the court to me immediately. What you're saying in there is I'm not disputing any facts. Okay, I'm not disputing any facts. This is called a confession and avoidance. Let's look at confession and avoidance. Now that's a common law, but in commercial, it's acceptance for value. But under the common law, it's called confession and avoidance. Let's look and see if you can confess to something and avoid the consequences of it. All right, if there are extenuating circumstances. In this case, this being a commercial matter, dealing with legal fictions, and there's no true injured party. All right, so let's look and see this real quick. We have to go slow. Let's get back to the dashboard. Right here, our dictionaries. We have a lot of dictionaries on SPC University. We got Black's, Bouvier's, Bureau, Funkin' Wagnalls, military dictionaries, Oxford's, Tomlin's, Webster's, Barron's. Got a lot of stuff over here. We got a very, very good catalog of books for you to study from. All right, so we got Black's right here, and we got Black's 1 through 9. It's right here. Going to look for confession and avoidance. Confession and avoidance. Let's look and see what a confession and avoidance is. All right, confession and avoidance. It appears 8 times. There it is right here. Confession and avoidance. A plea in which a defendant admits allegations but pleads additional facts that deprive the admitted facts of an adverse legal effect. Okay, so there it is right there. Now, this is under the common law, okay? It was under the common law, all right? So it's in the nature of a confession and avoidance when we're talking about what we're doing here. This is in the nature of that when you're doing acceptance for value. I'm not going to argue any facts of the case. I'm not subjecting myself under your statutory code because I'm a real living soul. I understand that these are for corporations and your jurisdiction is over commercial matters. This is what the general public didn't seem to understand. All this is related to Article 1, Section 8, Clause 3 of the Constitution. Notice that all the charges that he was naming are commercial in nature. And in case you're doubting that, let's look at some of the things that they're talking about on the federal level. We have Code of Federal 27 CFR Code of Federal Regulations 72.11. Let's look at this real quick. You know, we sound crazy over here, right? This shit gotta sound crazy to you. If you just tuning in for one of those sovereign citizen fail videos, I know it gotta sound crazy to you, you know? So let's get over here. Let's see this real quick. All right, so we're gonna do 27 Code of Federal Regulations 72.11. And oh, look at what we have right here, commercial crimes. All right, any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, and confidence games, and attempted to commit, conspiring to commit, or compounding any of the foregoing crimes, addiction to narcotic drugs, and use of marijuana will be treated as such were a commercial crime. Now, in case you didn't see your crime on here, they all fall under the first one, which is offenses against the revenue laws, which is everything is just a tax. These are taxes we talking about, man. It sounds crazy, I know. But I have to give some context so y'all can understand when these people go into the courtroom and you're a person watching these people go in the courtroom and you don't understand what's going on. He's like a crazy sovereign citizen talking about some gibberish or something like that. You are looking at individuals who are not very swift with using the information, and they do come across loony because he coming across loony. I'll admit that. How you, Sam? All the beneficiaries have been named. I'm the trustee. I'm the beneficiary. You're trying to attack my trust. You know, he's speaking to him like this man is going to admit on the record that this is what's going on. That's why you look foolish saying that shit, asking the judge questions that he's not going to admit to. That's why you got to learn how to use cornering questions. You're not finna admit to none of that shit on the record, fool. But he understands what's going on. He even took time to entertain him. He said, no, I'm going to say he's here. He knows what he's talking about. But he's trying to see, do he understand? Can he articulate it in a way? He's making an assessment of him. This is called a colloquy. When you start talking to the defendant and making a determination whether or not he's competent enough to handle his own commercial affairs. or represent itself? Let's keep going.
At trial.
He looks like he was okay. So I'm going to speak here for just a minute, and I'm going to kind of tell you where we are with this, and then we'll go from there. So, you know, you said a lot of things already that just simply are not correct. And here's where you're at right now. All right. And so you've been charged. There's 3 things at issue here. There's 2 statutes that are alleged to have been violated: violation of a special fuel trip permit, violation of vehicle operator refusing to comply with an officer. And those are both, I think, simple misdemeanors, which carry with them maximum penalties of 90 days in jail and a $1,000 fine. Pleas of not guilty have been entered. And then these cases, they're both criminal cases. And what happens is they either resolve through some sort of plea or some sort of agreement, or they proceed to a jury trial. And now, if you go to it, since they are criminal cases, it's headed to a jury trial, you're entitled to be represented by an attorney. Look like a previous judge had already ruled that, or found that you were going to, are you going to represent as the person, as the trustee of the person of Muhammad Idris, going to be present to contest the criminal charges against the named Muhammad Idris? Are you going to do that yourself, or do you want to have an attorney appointed to represent? I can screen you for court appointed counsel, or you can hire an attorney to represent yourself.
Do I have a standing to speak?
Yes.
Okay, I object to what the prosecutor has said.
Okay.
And I'm standing on, I am. Like
You're standing on what?
The trustee of the person is here, and the beneficiaries have already been named.
Okay.
It's not a trust and it's private.
Okay.
See, this is where this sovereign shit, citizen shit comes from. Because he do look stupid, what he's saying. He just keeps saying the same shit. First of all, one of their tactics is to try to railroad you into a trial. You got to be specific. Once again, Your Honor, let me repeat. I'm not disputing any of the facts in the charging instrument, Your Honor. All right, that's not an issue. There are no material issues with fact. I'm not challenging any of the facts in the charging instrument. That right there, they don't like that, because now you got them in limbo because they can't take you to trial. So the next thing out their mouth, well, are you pleading to these statutes? Well, you might have to plead guilty for the show, for the straw man. But this is where you need a public defender and use your attorney letter of advice. See, you shouldn't even be talking in these particular matters because you are a private citizen. This is why if they offer you a public defender, you always accept a public defender. And you don't fire a public defender unless he dishonors your request. And at any point he dishonors your request, you immediately fire him. And you put it on the record. You're in open court, you fire him. Your Honor, counsel is refusing to follow my instructions. Therefore, counsel is no longer necessary. I'll be taking over this. And I'd like to make a part of the record the written instructions I had for counsel that he refused to follow. It's about honor and dishonor. Let's keep going.
And I object to the prosecutor saying that representing myself, I object to that. I object to being the trustor. And I'm not here to give out gifts, reducing the public law or the public debt. Because I'm brought in as a trustor to give out.
Okay, what he's talking about right there is the charge is a lien. So they are drafting, okay, they're using these commercial liens to pay the public debt because we're in debt. And that's what he means is they're taking private commercial energy from the private and using the straw man as a transmitting utility and then to pay the public debt. Now, a good document to read this is What Does Acceptance for Value Mean by Byron Beers. He has a very, very good document. Let me pull it up for you so you can see it. That explains all of this. What does acceptance for value mean? This is a book right here by Byron Beers. This book right here has a lot of good information in it. A lot of good information. A remedy is a commercial right for those who acquire that right through an instrument. In the corporate United States, there must be a written recognition. This right here explains a lot of different things. And talking about when they charge you with something, what is actually going on behind the scene. See right here, he says dishonor has value in the public. Violation of statutes has value in the public. The violation of the statute is the presumed basis consideration for issuing the instrument. But if you have not promised to perform under those statutes, you're not obligated, and the issuer has no way of supporting his demand instrument. This is where you're getting a lot of this stuff. Commercial due process is not much more than the time and opportunity to compute an administrative remedy and produce a counterclaim. You can choose to use a sovereign statute or commercial remedies, but they should not be used simultaneously. Even though you might choose to use commercial remedies, you still need to use the person you represent in the public to access the commercial remedies. And all this stuff in there, a right is defined as a remedy. Debtors' remedies often include defenses against foreclosure on the express or implied terms of an express or implied agreement for which the security was given. There's a lot of things that are explained in here. A for V is based on contract law. If you think there is a presumption of a pre-existing contract through which you are presumed to be a debtor that has supposedly pledged property and your liberty as security for some presumed value given by the United States, it might be very important for you to negotiate something better, terms and a counteroffer. That's what he needs to be doing. But what you're doing is you are trying to get a win-win situation. Obviously, the state is trying to get some money, but they're trying to lock your ass up too. This is a nefarious situation behind the scene of them hiding the true nature of what's going on. They're really trying to get some money, but they're trying to get some money and lock you up. They're trying to get both. And this is when we come to a head, when you're in the courtroom and you're sitting there discussing this with these people. This is where everybody fails because they're not able to articulate this in such a way where you don't sound crazy.
Gifts and turn around, and what the court is doing is coming after me for the commercial promise. So for that reason, I am the trustee. I'm standing on that position.
All right.
And I'm not here to give out any gifts.
Okay, no one's here for any gifts.
So I object to that. The trustee of the person is here, and all the beneficiaries already been named.
All right.
And I'm not talking about the beneficiaries, which is the investors.
I have no idea what you're talking about. When you talk about the beneficiaries, I don't have a clue as to what you're talking about. So I don't even know what that means. I'm trying to figure out, where we're going to go from here. And I have an idea, but in a minute, I'm going to take up some of these. I'm going to take some of these other cases, and then
once again, he took this from the Judge Dale document. Let me see if I can pull this up in case you weren't around yesterday. Where is he getting this stuff where he keep talking about a trustee? I'm not the trustee. And, all the beneficiaries have been named. Where is he getting all that from, Yusef? That sounds like a whole bunch of, what the hell is he talking about? What is he talking about? And I understand. Let me see if I can get y'all some clarification on what he's talking about. The name of the document is called The Matrix and the U.S. Constitution. And I think it's on my website. If you go to my website and you go to Yusef L's top 10, you don't even have to be a member of my site to get this. It's just free for anyone. If you go to spcuniversity.com, I got top 10 documents for you to read. I'll put a lot of documents for you to read. And this is it right here, the Matrix and the U.S. Constitution. If we go down to around page 15, this is what he's trying to do right here. I'm going to repeat it again. 15. All right. And I'm going to start right here on page. I'm going to start right here on page 16. Under our corporate government, no sovereign can lawfully be tried or convicted of any statutory crime. I recently discovered how to avoid prosecution under the trust when a sovereign is taken before a corporate prosecuting attorney or a judge. First, the sovereign must inquire if we are on the record, and if not, insist upon it. Say nothing, sign nothing, and answer no questions until you are convinced that the proceedings are being recorded. Secondly, all the sovereign has to say for the record is, I am a beneficiary of the trust, and I'm appointing you as my trustee. Thirdly, the sovereign then directs his trustee to do his bidding. As my trustee, I want you to discharge this matter I'm accused of and eliminate the record. This is where the Form 56 comes into handy too, at the bottom of that thing. That Form 56. Fourthly, if the sovereign suffered any damages as a result of his arrest, he could direct the trust compensate him for the proceeds of the court by saying, I wish to be compensated for X dollars in redemption. Now, this is where he is getting this from. All right. But like many people, he never read that. He probably didn't even read this. Somebody told him this. It's just like the old saying goes, you know, if you take 100 people and put them in a circle, all right, and I whisper in a person's ear something, and then I tell them to whisper what I said in the next person's ear, and they go all the way around whispering somebody's ear, and it come back to me, this person whispering my ear, it's not going to be the same thing that I said initially. Because every time somebody changed one word like a and but and, they fundamentally start changing the meaning of what was said. This is why you need to know what originally was stated. And I see a lot of that going on in the internet. People just regurgitating information, and they don't even know the source of the information. Birth certificate authentication being one. So this is what he's trying to do. But obviously, he never read the instructions.
I'll come back to you, but
I'm the only witness on the case, correct?
no, you're not. That's not correct. No. Give me just a second here. Mr. Newcomb, you can mute up there, Mr. Idris, and then I'll come back to you here in just a minute. And you can go off camera, but don't leave the Zoom call just yet, because this is going to take some time. I'm going to take care of some of these other cases first. Mr. Newcomb, is your case ready? I don't hear him. And then Ms. Lazarek.
Your Honor, we'll be doing a change of plea today, but I'm just waiting for my client to log on.
All right. All right. So you can come back on the, you can come off the Zoom call there. Mr. Idris, you can come back off of mute. You can come back onto the Zoom call. So here's where we're at here. And I started talking about, and again, at this time, I don't want to hear anything about the trustee and the named or unnamed beneficiaries. My only question is, do you want to have an attorney appointed to be involved and help you with this case? I mean, that's a yes or no question.
The trustee of the person is here, and the beneficiaries have been already named. And I'm asking for the court to dismiss this case because
Okay.
I put myself in the position of a trustee.
Okay. The request to dismiss the case will be denied. I'm telling you that. And I'm going to ask my question again. Do you want an attorney appointed to represent you, or are you going to go it alone?
How can somebody represent me?
He put himself in the position of trustee. He just put himself in the position of trustee. But do you understand, now that I read you this, go back and listen to what he's saying. You see what he's trying to do. See, this is what happens. This is 90% of those cases. It's just people been told something by somebody. They don't really understand what they're doing. They don't know the source of the information. They don't know the principles behind it or anything like that. This is just somebody just went into court and told what to say. That's it. And this is how you're going to look when you do that. When you go into court and you just repeating what somebody else told you what to say. You don't even know what the fuck he's saying.
When I'm the trustee,
Okay.
and the beneficiaries have already been named. You can't even continue.
Why do you think that?
What does it have to do with thinking?
Yeah, that's a good question. Well, I mean, you're just telling me that, well, I've named the trustee and the beneficiaries are named who haven't been named to me. So I don't know who they are, and they're really not interested. I mean, if life were that easy, anybody could do that in any criminal charge. Anybody get charged with anything? Well, I'll just name myself the trustee of the person and name some beneficiaries, then you're off the hook. You know, things just don't work that way.
How come they don't
And
do
so
it?
in terms of, you know, at some point, on the, there was a scene where you were contacted by a law enforcement officer, or maybe even more than one. They identified some charges or some statutes you were not complying with, including, you know, the special field trip permit, and you refused to comply with the officers and things of that sort. So they refer that to the prosecutor's office. They're charging a crime. And I've told you what those two crimes are. And now, again, these cases either resolve, and if you've been on the Zoom call, which I think you have for a while, you've seen some of these cases resolve, or they go for a jury trial. And again, you've seen all these other attorneys who represent these folks. I mean, if they could make these cases go away simply by naming someone as a trustee or naming the charged person as a trustee, I mean, shoot, they'd all do it. And then nobody could ever be prosecuted for anything. So that's why I'm wondering why you think that. And now I'm losing my voice, but it'll come back, I promise. So if you're going to keep
Go ahead.
I mean, if you're just going to keep repeating that to me, then I don't have much of a choice other than we'll just set this to a jury trial, and then you can repeat that to the jury and see how that turns out. But I don't really have much of a choice here right now.
I object. Isn't the prosecutor supposed to be speaking and ruling between me and the prosecutor?
Say that again. I didn't understand that. Would you please repeat that?
How come the prosecutor is not saying anything? Why is the prosecutor silent?
Well, because part of my job is trying to identify who's here. And then the prosecutor did say that they want to figure out whether you're either representing yourself or you want an attorney. And so that started the conversation between me and you as to whether or not you want an attorney or not. And I frankly, I still haven't gotten an answer. You just, when I ask you that question, you just go back to restating yourself as the trustee of the person of Mohammed Idris, and then the beneficiaries have been named. So I want to get through that hurdle. And then, I have some responsibility to do some things here before we really hear from the prosecutor. Prosecutor will, I suppose, if this case goes to jury trial, they'll do that. They can negotiate with you some sort of resolution to the problem if you wish to do that. I can set this over for a period of time to give you an opportunity to do that. But and again, you still haven't even admitted that you're the person who was pulled over by the police officers on that day. So, I mean, we kind of have to get through some of these preliminary hurdles before we can get to that.
The trustee of the person is here, and the
I know.
beneficiaries have
You
already
have
been
said.
named.
You have
The
said. You have said.
the beneficiaries have already been named.
All right.
Do y'all think he knows? I want y'all to put in the chat if you believe he knows what he's saying. Does he understand? I want y'all to put in the chat right now, yes or no, if you think he understands what he's saying to the judge. If he understands what he's saying. Do you think he understands? Just put a yes or no in the chat right now. Does he understand what he is saying when he says the beneficiary has been named? Do you understand that this is the overwhelming, the vast majority of videos that are on YouTube right now. This is why they have come up with the term called sovereign citizen. All right. This is why I started a school. In case you're wondering why I'm not teaching about discharging debt or trying to make some quick money on showing how to discharge debts and all of this, because of this right here. Okay, I've been doing this longer than any other person on the internet. And I see this every day. This is what I started the school for.
Do you understand that the prosecutor is an attorney who's passed the bar, practiced law in the state of Washington, appears here fairly regularly, and knows the rules of evidence and criminal procedure, and quite familiar with them, given that that's what their job is?
I object to being the trustor.
Okay. Do you understand what a prosecutor's job is?
I object to being the trustor.
Okay, a trustor is a person that creates a trust. He's saying he's objecting to being the trustor. What is really interesting about all this is that he's a commercial driver. So he falls under their jurisdiction. He falls under their purview because he's involved in commercial activity. All right, so he's not under really even using these defenses in a way, it really don't have no application for what he's trying to do right now. All right. It's just, I don't know what he's attempting to do at this point. I don't know he hasn't given any instructions. It is nonsensical what he's saying. He don't know if he's the trustee of the trustor. He don't know what a trustor is, I bet. It sounds like somebody is behind him telling him what to say. That's almost what it kind of seems like to me. All right. And it's just like nobody, now I will admit this judge is entertaining this. It looked like he's trying to give him can you kind of sense that the judge is rooting for him and trying to look, man, I see what you're trying to do. Let me help you out here. If you could just make it make sense. If you can make it make sense, help me to help you.
All right, you can go ahead and mute back up. You can stop your camera, and then I'll come back here in a minute. All right, Mr. Idris, you can come back on the Zoom call, please. Activate your camera. So I'm just going to talk for a few minutes, and then I'm going to tell you what we're going to do here, going from here. It looks to me like your first appearance on these cases was on July 17th, and speedy trial runs through right now, October 15th, 2023. So you are charged, as it looks like you were in front of a pro tem back on July 17th. You're charged, right there, with 2 crimes and there's 1 infraction. Pleas of not guilty will be entered. Anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney, which I've talked about. You also have the right to go to trial and call witnesses and so forth. And so let me finish, please. Don't interrupt me. I know what you're about to say, but I'm going to talk for a while here. So just please don't interrupt me. At the end of it, then you can say what you're going to say. All right.
My apologies.
So this case has started. This case is headed towards trial, apparently. And if my voice holds out, the trial is going to take place someday before October 15th. You have the right to an attorney, as I said. You also have the right to represent yourself. If you choose to represent yourself, I just want to advise you that you would be at a serious disadvantage. The prosecutor, as I tried to explain earlier, is a trained attorney, been through law school, been practicing law for a while, well-trained, well-versed in the rules of evidence, well-trained, well-versed in the rules of criminal procedure, been through jury trials before, they know how to conduct them. And so if you were to represent yourself, you would be at a huge disadvantage. It would be to your great advantage to have an attorney appointed, or you can hire an attorney to represent you. But as I said before, you do have the right to represent yourself. And normally you go through some sort of conversation with folks. I've been doing this job for a number of years now. I've had several people represent themselves. Normally there's a conversation I've had with people about asking them that they're aware that if they represent themselves, they'd be at a disadvantage. I tried to engage in that discussion with you. You just kind of reverted back to repeating that you're the trustee of the person and the beneficiaries and the name, so forth. But rather than go through the question and answer portion, I'm just going to tell you that's where we're at. So we're going to set this case. We're going to do 2 things here today. We're going to set the case for trial. You're going to get notice in the mail of that. You're also going to I'm going to set a status hearing or a pretrial hearing in about 3 weeks. And then somebody else, maybe it'll be me, will probably try and go through all this again. But I'm going to tell you some things that, you said you object to this and you object to that, and you're free to object to anything you want. But I have the ability to either overrule the objection, which means, turn down your objection, or sustain your objection. And I'm having trouble actually understanding what your objections are. And so, and again, I'm going to lay out some of what's going to happen at trial if it goes that far. In a trial, they have a group of citizens come in, both the attorney and defense attorney or the person represent themselves, and the prosecutor has an opportunity to question them, talk about the issues that might come up in the case. And then they can eliminate who they don't want on the jury. And then 6, you will end up on a jury, and then the state will present their case. You or an attorney, or you on your own behalf, or you as the trustee of the person, can present your case or explain to the jury why you think you should be found not guilty of what you're charged with. And so in the grand scheme of things, frankly, the charges that you're charged with are not far from the most serious that we see around here. They're not. But they are crimes, and they are in their own way serious. And so I don't know whether anything I've said has made any impression on you at all. But that's what's going to happen here today. And if you wished in that, so this case is headed for trial. And like I say, we'll do a sometime before October 15th, but we're going to do a intervening, and I'll tell you when that is. We can, why don't you set up just a status pre-trial for like about 3 weeks. And you can think about what's going on here. You can think if you want to take some alternative place. If you want to just come to court and keep repeating the same thing to me when you get in front of a jury, you keep repeating that same thing to somebody else, you know, that's, I suppose there's no way I can stop you of doing that, but I'm just trying to enlighten you on what's going to happen. And, you know, some of, you know, your objections you talk about, see, that's the advantage the attorneys have. The attorneys know when objections are well-founded and when they're not. And I kind of get the sense from you that you really don't have a complete or accurate idea of what this is all about and what's happening. And so I tried to spend some time explaining that to you as best I could. And I guess I told you I'd let you speak, or hinted that I would let you speak. I'll go ahead and tell you. Do you have any response or any thoughts on this, or would you understand this is going to trial, or go ahead. I've said what I'm going to say. I'll turn things over to you. Any response to any of that?
Again, I object. I'm standing at what I said.
Okay. And what
trustee,
specifically do you object to? Just so I can create a record, so I'll make a ruling on your objection. What are you objecting to?
I'm objecting to everything you're saying. It's a hearsay. It's a assumption, a presumption. It's a tacit agreement. It has nothing to do with the facts. That's why I'm the trustee. It has something to do. It has everything.
Sometimes I believe that they make these videos to make people look crazy, because I don't think he understands what he's saying. I don't understand what he's saying. I don't know what he's asking for. I don't understand. You know, I don't know what the fuck he's doing. I don't know what he's trying to say. I object to everything. He just throwing out words. Everything you're saying is a presumption and a something. He just have somebody, seems like they listened to my show one time, heard words like assumptions and presumptions and trustee, and I'm appointing you this, and that's it. And I see nothing here that is indicative of an individual who's done any type of deep study. This right here is just someone who did an cursory examination into these topics, got into trouble, and looked for a quick fix. This is quick fix. This is what is that you find in mass in the case law when it comes to this. And this is the kind of person that will come to you and say, I tried to do that and it didn't work. This type of shit right here. Oh, I tried to use that. That shit didn't work for me. Nigga, let me look and see what you said in court. Oh, I see why it didn't work.
To do with the trust law. The trustee of the person is here, and the beneficiaries have already been named. That's why I have a trust, and my trust is private, and I don't see your trust. And in the trust that you have, the trust that the prosecutor has named you as the trustee. That's why you keep asking the prosecutor what they want to do, because they named you the trustee. And you guys brought me into court to bear gift, to give out gifts. And I'm not here to give out any gifts.
Right.
I'm here to object to giving out any gifts. That's supposed to reduce the public debt. Am I wrong?
Yes. Yes, you are. And that's frankly, that's kind of the sad thing, because I'm really not sure completely of what you're saying, but a lot of the things you just said are quite simply not true. And I asked the prosecutor where they wanted to go in the case because they file the cases, they choose to go forward. Sometimes, as you've seen today, if you've been paying attention, the prosecutor said, no, Your Honor, we're going to dismiss this thing. And so I dismiss it. So I asked the prosecutor, they filed the case. What do you want to do with this case? They said they want to go forward, which brought about this conversation that we've been having. And that's just one example of one of the things you're wrong about in terms of this whole trustee thing. I don't know what that means to you, but I have an idea of what a trustee and is and things of that sort. And I don't have a trust. I'm not anybody's trustor or trustee. In this court, neither is the prosecutor. And so when you say, am I wrong? You know, the short answer to that is yeah. And unfortunately, and I'm taking some time to try and explain it to you, but I just don't feel like I'm breaking through. But to answer your question, am I wrong? Yes, you're wrong about a number of things, which is really unfortunate that I can't explain that to you or make that clear to you.
What's your evidence? Evidence is clarity.
I'm sorry?
What's your evidence that I'm wrong?
Well, I mean, you know,
This is a good question. I wouldn't have phrased it like that. This is where you do your conditional acceptance. I will conditionally accept the honorable judge's contention that I'm wrong upon proof of claim. He can provide evidence for the record that would demonstrate that I'm wrong. You know, he's just talking. You know what I'm saying? He's right. Where's the evidence? You know what I'm saying? But but I don't really understand what he's saying either. I know the information and I'm having trouble trying to see where he's going. Where is he going with this? You know, it's like I'm having trouble kind of understanding it myself. But he has a rudimentary understanding of it. And he definitely has the nerve. He got the nerve. You know, that's always a good quality to have. Balls. You know, he ain't afraid. And, you know, what is one of the 48 laws of power? Enter with boldness. Any mistakes you make can be covered with more boldness. Remember that.
Other than me just telling you that I'm not a trustee, I can't prove something doesn't exist. I mean, there is no trust. There's nothing else. And I have no documents that saying there's not one, and I don't have any document. There is no document saying that there is one. And so again, that's on that single issue. That's.
So you're not coming after my personal trust?
No.
So personal
And again,
trust
I'm not
doesn't
sure.
exist?
Well, let me rephrase. I'm not sure what that means. Again, you're charged with a crime. That crime needs to be resolved or either through trial or resolution of some kind. And so in terms of coming after your personal trust, and by the way, you know, I'm not the one who filed the charges. That was done by the prosecutor and all of that. And so what they're trying to do, I think, and I don't know this for sure, and I'm just trying to do this by way of explanation, not because I'm on anyone's side. You know, it's their responsibility. They're bringing the charge. It's their responsibility to prove it beyond a reasonable doubt. It's your or the defense attorney's role to say, explain why the charge should never have been brought, or that there reasonable doubt exists as the charge was ever committed. That's what this is about. This whole trust thing, I think you're just going down a way that's really doesn't have any relevance to what's happening here. And I've tried to explain that to you, and I'm more than willing to continue to. We can't go at it all afternoon, but I'm trying to make this as clear as I can to you. But again, it's unfortunate. It's a failing on my part that I'm not able to break through to you.
Your Honor, if I might for a moment.
In a minute. So I guess we'll set it for status hearing. We'll set trial dates, and then we'll just go from there.
Your Honor, based on this conversation, the state has concerns about the defendant's competency.
Yeah, we're not going to go down that route right now. And so you can raise that, but I'm not denying that without prejudice. But at this time, we're not. For one thing, as you well know, given the nature of the charges and given the schedule of this case, will drag everything on we'll be here for the next couple of years. And at this point, I'm not prepared to do that. So you can bring this up again if you wish. But for right now, we're not going to go there.
You see how he talking about the case can go on for years. See, that's one of the things that's what happens when you start using these processes. You can hang them up, and they'll be going back and forth with you for a long time until they just give up or you give up. I call it fatiguing you into compliance. That's why they like to arrest you. They like to get you in jail because then they can just let you sit in there and forget about you until you just say, hey, I give up. Let me just sign this plea deal and let me get out of here. But it's a lot more difficult when you're free. And these charges ain't serious enough to put them away for a very long time. So that judge, he's thinking about some things. Once again, you always look for win-win situations. You don't look for win-lose situations when dealing with the state.
And do you understand what the state just said to me and what I turned them down for? Again, that's a yes or no question. The representative from the state, the prosecutor, she just said something to me. And I said, no, we're not doing that now. She made a request of me. And so do you know what that request was?
I am the trustee, and the beneficiaries have been already named. So,
All right. Did he been sent discovery?
He messed up already. He called himself the trustee. He's supposed to be the beneficiary. I'm the beneficiary of the trust, and I'm appointing you as my trustee, man. He ain't even doing it right. He's not even doing it right.
No, Your Honor,
Okay.
because
Yeah, I understand why. I understand why. All right, so what's 3 weeks? What's 3 weeks from today? When's the trial date?
September 13th.
We're going to reset this to September 13th. Put it at the end of the calendar. Or
Okay.
what time?
2:30.
At 2:30. That'll be your next court date. You're free to go. Mr. Fugate, are you back?
Y'all, I don't know what to say. I don't, but this, I wanted you to kind of look into my world because I'm a teacher, and this is the type of thing I have to deal with on a daily basis. When I'm getting, from people want to get consultations and everything, there's a lot of things I'm trying to muddle through. It's a lot of work here on my side of the table. It's a lot. This requires a lot of work. Putting together this curriculum on SBC University, trying to get people an understanding of some information that, quite frankly, takes about 3 years to make you functionally literate with the information. But people have exigent circumstances that come up in their life, and they want some immediate resolution right off the bat. This is the conundrum. This is what I'm dealing with. Now you see. Now you know. There are rules to the game. Rule number 1, there isn't any money. There's no money. This is the key to everything. This is how they taking away privacy. This is what the whole system is predicated off of, a debt-based currency system. Rule number 2, there's a public and a private, and they do not mix. They don't ever mix them. Don't you ever mix them. This is one of the foundational principles that lets you know that the straw man is an artificial person, because the real people and the fictitious people cannot interact. When they say the state of Georgia versus you, how the fuck is the state of Georgia going to go against you? And the state of Georgia is a construct of someone's mind. And you have the right in the Constitution to face your accuser. And they say, well, who brings the claim? They say the state of Georgia. I call the state of Georgia to the witness stand. Yeah, that sounds crazy, don't it? It also sounds crazy when you trying to make me believe that a fictitious entity and can be on par with a real person. That sounds ridiculous to me. Anyway, that's my review for today. I'm hoping you can garner some pearls of wisdom from all of this. I will have another case tomorrow to review. There wasn't much I could say on this right here because I didn't really understand where he was going. I can just kind of just show you where the information came from. The documents that you need to read, obviously, the matrix in the U.S. Constitution. What does acceptance for value mean? The matrix in the U.S. Constitution is by Judge Dale. And what does acceptance for value mean is by Byron Beers. Those are your 2 study materials for this. If you want to get an understanding of what he was attempting to do in this video, those are the documents that you need to read. With that being said, I ain't going to keep it too long. You know, that was it for today. I'll see y'all tomorrow. Same bad time, same bad channel. Y'all look at this again, and you want to be on the air? Come over here. Come over here real quick. Come on over here. Come here. Because she want to be on the air so bad. Come on. Come on. Now, come on over here. Come on over here and everything, because you just talking in the background. You want to be on the air. I'm going to put you on the air. I'm going to make you a star. She all in the back, boy, just hating like a baby mama. Boy, you know how these, boy. Anyway. Anyway. All right. With that, I'll see y'all tomorrow, man. Peace to the gods. Study, stay alert, and learn the rules to the game, all right? Peace, y'all. I'm out.